for in terms of the assent to legislation.
Yes.
Things of that kind. And of course the choice of his cabinet and matters of that nature. Yes.
Now, I want to go on this point, and it's something that the entire society is grappling with. When Parliament legislates, the Constitution says that the Attorney General, he is the principal legal advisor to the government.
Yes.
He doesn't represent the people. He's the principal legal advisor to the government.
Mm-hmm.
When Parliament legislates, the bill that is so passed in the Parliament goes to the President for his assent. Then after such period of time, if he doesn't do that, it goes back, and then a certain waiting period of time. But what we have been hearing recently is that the Attorney General is saying that he is not going to send any, the bills come to him, and he's not sending any bills to the President to assent to it. I want you to explain to this clearly to the general public. What is the actual process? Because it is my understanding from the reading of the law, the supreme law, the Constitution, is that the Attorney General's function is not one in which he decides if the bill should be assented to, but it's the President himself has to decide on that.
This is a topical issue. I'm glad you raised it. As a matter of fact, I'd intended to write something on it. We have to go back to former times when we were a dependent territory, and then soon after we became independent. When we were a dependent territory, Her Majesty's government had reserve powers. They had power of disallowance. If your parliament, if the legislature enacted any laws, they had power to disallow the legislation, or the government could have reserved it for the signification of Her Majesty's pleasure. They had that, those powers resided in the UK government. With independence, when we became an internally self-governing state, the only reserve powers that the UK government had was in terms of foreign affairs and defense, because those were the reserve powers. When we established the Republic and then became independent, Her Majesty's government no longer enjoyed those reserve powers. Therefore, when the legislature or parliament passed a law, it went to the Governor General and then later the President to be assented.
I went to the Governor General first?
Governor General, then, you know,
as the Queen's
representative. Now, what has happened now, especially after becoming a republic, is, I think, this matter is going to be subject to some litigation, but I can still speak on the issue. What happened in the past was that when the legislature passed a law, it went to the governor or the Governor General afterwards for an assent certificate. And that kind of, you know, was to give effect to the things like the reserve powers and whatnot and so on. So the Attorney General, it was his duty to advise on the enactment of the law.
Advise whom?
The president.
Yeah.
So you had this, what we call assent certificate, which went under the hand of the Attorney General, indicating to the head of state that...
The Attorney General or the Governor General?
No, the Attorney General. Yeah, that he could assent to the bill. But that is no longer necessary now. Argument being that a law which has been passed by Parliament, the Constitution now provides that the President can return it to the legislature, but he has to give reasons for so doing. There are those provisions now in the Constitution. You will recall some time ago a number of bills were passed in the Assembly, and when they went to former President Jagdeo, he sat on them, and then they had a dissolution and the legislation fell. When you have a dissolution of Parliament, laws which have not
been assented
to or gone through the process
has to be resubmitted.
Correct. And as a result of that, a number of the bills had to be reintroduced in Parliament. I don't know whether you remember those circumstances,
yes.
But that is what happened. Yeah. Now, with the present arrangement, what has happened is that the Attorney General is using a mechanism which was used in colonial times, where the Attorney General advised the head of state that it was in order for him
to sign.
To sign.
But are you saying that this Attorney General, for his own purposes, can just sit on it, just hold it?
It's not the Attorney General.
No.
He's the President can sit in it, not the Attorney.
No. But the President, I'm saying, cannot sit on a bill under the Constitution.
The present arrangements.
The present Constitution.
He has a certain amount of time in which to send it, which is reasonable.
Yes, right. Under the present Constitution, he must send it back
to the Parliament,
indicating the reason for him not assenting to the bill.
What is the role of the Attorney General in this case, specifically in this case?
I think what has happened is it's a continuation of what was done in former times.
In times, okay.
Speaker, sorry,
but
former clerk
really,
that was his contribution. Former clerk Franklin Ryan said.
But let's put it this.
As he said, from time immemorial.
Yes.
They're not coming out of their.
Let's put it this way. I suppose what the Attorney General is doing is a sort of, as a precautionary measure carried over from the former times, colonial past. Right.
But with different objectives.
But now the position is that once legislation is passed by the National Assembly, the President must either assent to it or refer it back to the Assembly with his reasons for not assenting.
So in other words, the Attorney General has what is called a limited private role directly to the President in terms of enabling the President to just have an understanding of what is written there as the legal advisor, because it's law. So his role is limited. His role is not one whereby he can come out and say that I am not going to have the President sign. Right, okay. So just that's one of the things that, when I talk about what is happening.
I think it's merely a precautionary measure carried over from the colonial past.
We still have time. We still have time.
Yes.
I bring a layman's perspective to this. I've never, during this program, reminded you that Dr. Thomas is an eminent corporate attorney of international repute, I might add, but he doesn't like that being said too much. And we've already listened to part of the CV of, I want to say Dr. Pollard, I mean Senior Counsel Pollard. But I bring a layman's perspective to this, and I'm glad about that, because the thousands out there whom I represent don't bother themselves with these matters. And our function here is to sort of stimulate this. There have been a plethora, a number of letters recently to the press in our leading dailies, and it's good to see that, but my problem is they're limited to an interested group of citizens, which in itself is good, but the questions they raise must be considered by all of us, my viewers and listeners, and the GNCPP's role, one of them is to do just this. And of the many letters, I've saved one from Joseph Singh, Major General retired Joe Singh, and one the other day, Senior Counsel. This is a bit provocative, but I'll ask through Dr. Thomas your quick views, not views, but your opinion on this. It's from a very prominent attorney we have now, attorney cum, C-U-M, cum, politician Nigel Hughes, C.A. Nigel Hughes. And he's saying, look, Guyanese, I hope you're now willing to get your political representatives to start thinking about urgent constitutional reform. And he has his reasons. But this is how he put it. He says, look, in Guyana we now have a house that can pass motions but cannot enforce them because of what the Attorney General has said. Then he says, the National Assembly, whenever it sits, gets all dressed up but has nowhere to go. And people have been saying, look, they would not sign and send things. We have a president who is vested with all executive power, and I have the powers of the president right here, Article 89. We have a president who is vested, this is the views of Hughes, I'm rhyming, with all executive power, part of the parliament, but not responsible to it, who has representatives in parliament who cannot be effectively censured or disciplined in spite of their transgressions. And best of all, a president who is not liable for any of his actions, either in the assembly or before any court. He says, what a great republic. And then he's asking now for constitutional reform on a number of matters before elections. I wish to hear your wise words on the views of this gentleman, who is not without some knowledge of constitutional matters. The powers of the president and this sort of thing. It says here, I wanted to ask you to, let me get it in, then I'll shut up. There shall be a president of the Cooperative Republic. Boys and girls, vendors, Article 89. There shall be a president of the Cooperative Republic of Guyana, who shall be head of state. I understand that. The Supreme Executive Authority. BRYNMOR Pollard, what does that mean, the Supreme Executive Authority?
It means that he is the supreme, I don't want executive officer.
Head of a government. Head of state, we know that.
Head of state, yes. Head of state.
Supreme Executive Authority means what? Head of government? And
yes, that's right.
I see.
Yeah, because it's an executive president that you have.
Yeah. If you look at Article 50, as you have correctly pointed out, Mr. Fenty, the president has co-opted, or the way that the Constitution presents it on the Article 50, is that they have co-opted within the presidency of itself powers within the parliament itself, powers within his own self-presidential powers, and then he has this powers out of the cabinet. Now, when we refer to what they did with Article 50, and you look around at the state as being, they took out the National Democratic Council,
NCLDO and the Supreme.
And you see those powers were inevitably vested within the local government ministry, for which now the local government ministry goes around and setting up all these management,
IMCs they call them.
Right, interim management committees, right? So they took away the power from this national democratic organ,
Yeah.
vested the power within the local government ministry, and they themselves, the government took that powers for themselves. They grabbed that power for themselves, and they're setting up. It's interesting enough that the Constitution does not allow a minister or even a minister within a ministry to fire a public servant. He can make a recommendation. But we find that and this is the effects it has on civil
Well,
society.
let me say this. The firing of a public officer is a matter for the Public Service Commission.
Indeed,
Yes,
indeed.
Unless, I suppose, if the person is employed on contract or something like that. But basically, that is the power of the Public Service Commission.
Indeed. The minister is
And the counterpart, you know what I mean, the Police Service Commission.
right.
Yes.
If you look and see, there are a plethora of letters that public servants that are part of the public service union or members or former members, I don't know how you look at that, they would bring you these letters saying that, and it's under the minister's signature or the minister within the ministry signature, that he has been empowered by the minister to relieve you of your duties. Right? That is a civil and fundamental right violation right there in of itself. Right? So when I speak about bringing effect to Article 13 and the things that we endeavor to do as a Guyana National Council on Public Policy in trying to get redress, and let me touch on this one point. During the course of the elections,